Good morning. Are you Ronald Spikes?
Yes, ma'am.
And Mr. Spikes is charged with the offense of manslaughter in cause number 25 DCCR 0920. Mr. Macon has filed a motion asking me.
No, he was arrested for murder and indicted for manslaughter.
Intentionally and knowingly causing the death of an individual.
Let me look at the indictment. It shows I don't know why the heading
Heading says manslaughter, but the language.
did then and there intentionally and knowingly cause the death of an individual, namely Rowan Williams, by striking him with an automobile. So at least on the indictment language, that would be murder. I know it's not, the headings are not sometimes.
All right, today's courtroom lineup is heavy. We've got a bond hearing that suddenly turns into a murder charge, followed by a fast-tracked guilty plea on aggravated robbery. This is one of those sessions where freedom, decades of prison time, and legal technicalities all collide. Stick around, because one word in this indictment changes everything.
Important, but I think that needs to be adjusted and changed, especially if that is what is in, that's what's in Odyssey. So that's showing up on everything with the wrong stuff. So that needs to be amended if you can. Take care of that later. So based on that, it looks like the offense is actually the first-degree felony offense of murder, Mr. Spikes. And Mr. Macon has filed a motion asking that I reduce your bond. Bond is currently set, thank you, currently set at $800,000. Mr. Macon, do you wish to call your client?
Yes, Your Honor.
Sir, if you'll please raise your right hand the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead, Mr. Macon.
Now, what's your name?
Ronald Spikes.
And Mr. Spikes, you're the person charged with the offense.
Yes, sir.
Do you have enough money, you or your family, to post a $800,000 bond?
No, sir, I don't.
Did you catch that? The paperwork says manslaughter, but the language says intentionally and knowingly caused death. That's murder. Huge difference. Manslaughter can mean years, murder can mean life. This isn't just a typo, this affects bond, strategy, and the entire direction of the case. Paperwork matters, folks.
Now, before you were arrested, I mean, in the past you were in lots of trouble, right?
Yes, sir.
And you've got some priors. But in the last 10 years, have you been in any trouble?
No, sir, I have not been in no trouble.
Okay. And you have your wife living in this area?
Yes, I have my wife, my family, and things.
Okay, and your family, and you have a job. Were you able to make bond?
Yes, sir.
And that's with your father-in-law, Mr. Gonzalez, correct?
Yes, sir. Yes, sir.
And that's at 365 Spratt Middle?
Yes, sir.
Okay, and did you also work for Zachary as a heavy equipment?
Yes, sir, I do.
So you've always been working on?
Yes, I have,
Do you
sir.
have any assets whatsoever? Real property, coin collection,
No,
anything
sir.
like that? And you're asking the court to set some reasonable bond so you can get out and go to work?
Yes, sir.
Mr. Smith, any questions? All right, any other witnesses?
No.
Mr. Smith, what is the state's position?
Judge, he does have a prior from 1998, he was served 4 years TDC. So whatever, if it's murder, he would be 15 to life at least. And if it's manslaughter, it's 5 to life. State court is reasonable.
Here's what the judge is weighing right now: community ties, employment, past record, and whether this defendant is a flight risk. Bond isn't about guilt, it's about showing up to court and protecting the public. But when you're facing a first-degree felony, every dollar on that bond carries serious weight.
Mr. Macon?
Your Honor, we think that $800,000 bond is excessive and would ask that it be lowered.
I am taking judicial notice of the court's file, which includes the probable cause affidavit, as well as there was a letter of support that was sent by Mr. Macon from a Rocky Johnson. Were you able to review that, Mr. Smith? I think it was emailed.
I believe it is.
Okay.
November 16th.
Okay. Speak up, please.
It was from November 16th of 1998 for a 4-year sentence.
All right, 2, possession of controlled substance, same date. Got it. Okay. What I'm going to do is I am going to grant the motion for a bond reduction. I'm going to reduce the bond to $500,000. Sir, did you want to say that again louder?
Boom, bond drops from $800,000 to $500,000, but freedom comes with a digital leash. House arrest. GPS monitoring 24/7. This is modern justice. You may leave jail, but you're never really off the grid. One wrong move, one missed signal, and you're right back in cuffs.
You did say something.
Well, I didn't say nothing to you.
I'm going to reduce the bond to $500,000. A condition of that bond would be, if you make it, that you are on house arrest and required to wear a GPS monitoring device at all times. And we will get the case set for an announcement as quickly as possible. All right? Sir? That's what it's set at right now. All right? You can go back with the bailiff.
Can I ask one question, too?
What?
I'll be back.
All right, are you LaCaven Jenkins?
Yes, ma'am.
And Ms. Perazzo, will your client waive the formal reading of the indictment in each case? Mr. Jenkins, in cause number 24, DCCR 1026, you're charged with the first-degree felony offense of aggravated robbery, and that is from March 3rd of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
And then, in cause number 24, DCCR 1027, you're charged with the third-degree felony offense of fraudulent use or possession of identifying information from March 12th of 2024. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily? Answer out loud for me, thank you. And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the computer some documents in each of those cases that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Perazzo?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand if I follow the...
And just like that, we pivot from bond battles to straight-up guilty pleas. Notice how the judge carefully confirms everything is voluntary. That's appeal-proofing the case. Once Jenkins says guilty, the leverage is gone. No trial. No jury. Just sentencing. This is the quiet moment where a future gets locked in.
agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal.
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Jenkins is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of guilty in each case freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. In cause number 24, DCCR 1026, find sufficient evidence to find you guilty, and at this time, find you guilty of aggravated robbery. Sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am making an affirmative finding of a deadly weapon in that case. And then in cause number 24, DCCR 1027, also find sufficient evidence to find you guilty, and at this time find you guilty of fraudulent use or possession of identifying information. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm going to hand you, in each of your cases, the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Perazzo. All right, good luck to you, sir. You can go back with the bailiff. Thank you, Ms. Perazzo.